conversation.
Good morning, Collin.
Rick, we got a decision yesterday, 4-3 decision in Legislature versus Palm. This was over this extension of the Safer at Home order. Summarize the question before the court and what was the majority opinion?
Well, the question before the court, as we've been emphasizing, was not about the merits of the Safer at Home order. It was about how it could be adopted. Under Wisconsin law, the governor has the authority to declare a public health emergency under Chapter 323. That's the provision of the statutes that enable the governor to do that. But that declaration of a public health emergency is time limited. It can last only for 60 days unless it is extended by a joint resolution of the legislature. There was no joint resolution of the legislature extending it, and so it did expire, and it was anticipated to expire on May 12th. So when the governor decided that he wanted to extend the initial Safer at Home order, which was issued in March, he had a choice to make. He could have gone to the legislature and attempted to work something out with them with respect to declaration of extension of a public health emergency, or he could choose to act unilaterally. He chose to act unilaterally. And the way that he did it is by arguing that the Department of Health Services, under a separate provision of the law, Chapter 252, had the authority to extend the Safer at Home order for an indefinite period of time. And he based that on broad language in Chapter 252 that gives the secretary the authority to do things to control the outbreak of infectious disease. So when you look at the extension of the Safer at Home order, which was issued in mid-April, it no longer relies on the public emergency authority, but is solely on this Chapter 252 power. This would be anomalous to say that a public health emergency is carefully limited and checked by the legislature under the law, but yet there is this back door through which the Secretary of Department of Health Services can essentially do everything the governor could do, but free of any of the limitations that are placed on the governor's public emergency authority. And so the lawsuit was about whether or not the secretary really has that authority. And the court, as you indicated by 4-3 decision, concluded that she does not, that she may not proceed by order, but she must proceed by rulemaking. That is a process by which an agency makes a rule, and there are a number of procedural steps that have to be taken. There has to be public notice, there has to be provision for a comment, there has to be a scope statement approved by the governor, the final text of the rule has to be approved by the governor, and most importantly for our purposes, there's an opportunity for legislative oversight. The Joint Committee on Rules and Regulations in the legislature can block the implementation of the rule. And there are procedures for doing it on an emergency basis, for doing it much more quickly than we normally do it. But the court concluded that the secretary erred by not proceeding through this rulemaking process. It also went on to suggest that the scope of the Safer at Home order was overly broad and could not be supported in all respects by the statutory authority that she has.
So I think that's a really interesting explanation of what occurred, because so much of the coverage and so much of the opinions about this decision kind of basically fall into, well, whether it's a good or a bad thing. And I think what you're describing here is what the court, they had a question before them of whether the DHS secretary had the authority, one, the authority to do this unilaterally, and two, did they go through the right process to do this? So what I'm hearing from you is that in another world, maybe back in April, she could have promulgated this as a rule. It could have gone through a certain process, and this could have been actually done legally.
That's right. As far as the court is concerned, had she proceeded through the rulemaking process, uh, she would have been able to promulgate a safer at home rule, not an order, a rule. And it's not clear from the court's decision how far that rule would be able to go. The court suggested that she had gone too far in banning all travel, in closing all non-essential businesses. And so the rule might have had to ultimately have been narrower than the one that was adopted. But a good way to think about this case is that it wasn't so much about what we should do, but how we should do it. And whether or not we had reached the point where the governor could no longer act unilaterally, but had to proceed through a rulemaking process that has a number of procedural safeguards and opportunity for legislative oversight, or if that was for some reason deemed to be inadequate, whether the governor would then have to go to the legislature and say, look, I want you to enact a law that will govern the way the next chapter of our response to this virus will be. And of course, that would require some amount of negotiation and back and forth between the legislator and the governor, because the legislature could pass the law, the governor has the power to veto it, so they would have to reach some type of accommodation that both of them were able to live with.
So before we move on to the implications of the decision, the decision was 4-3, not 5-2, as many might have expected. There was a dissent from Justice Brian Hagedorn. So wondering if you could explain what he dissented on and what your interpretation of his reasoning was.
Well, there was a constitutional overlay in this case. So the legislature did not ask the court to declare Chapter 252 unconstitutional. It did ask the court to consider a rule of construction called constitutional doubt. And that rule says if you think that a statute might be unconstitutional, then perhaps you should construe it narrowly to avoid the constitutional problem. The brief that we filed on behalf of the Independent Business Association of Wisconsin and a couple of small businesses explained why, if the statute were interpreted to give the authority to essentially lock down the state indefinitely to a single executive officer, it would be unconstitutional. It would be a violation of the separation of powers, which vests the legislative power in the Senate and the Assembly. It would basically be giving this executive official acting at the direction of the governor the power to legislate, right, to make laws, commands that we would all have to follow with, subject to criminal penalty or fines. And if you look at the majority of opinion, they were very concerned about these constitutional issues and about the separation of powers. Justice Hagedorn, I think it's fair to say, didn't want to get into that, and basically said, look, the legislature didn't ask us to find this unconstitutional, and so we shouldn't really worry about that at all. And we should simply read the statute. And, if the legislature gave their power away, then the legislature gave their power away. Our view, of course, is the Constitution doesn't permit the legislature to give its power away, that the separation of powers is not for the benefit of the people who exercise the power, but for the benefit of the people. I think Justice Hagedorn thought that was not the case that they had. He didn't believe that the legislature should even be able to complain about that. His view was that if they gave their power away in an unconstitutional manner, then somebody else has to bring the lawsuit and not the legislature. And so this led to, some fairly spirited exchanges between some members of the majority and Justice Hagedorn. I would not read too much into Justice Hagedorn's dissent, because I think for the most part, he was making a very legal point that was predicated on the litigation posture of this case. And so it's, I don't agree with how he came down on the case, but I think it was because of the way that he saw the case coming before the court.
So let's move on to the implications of this decision. I know there's going to be a lot of different directions we can go with this, and there's some different fallout. So the governor suggested last night, I think, that they're going to now go through the rulemaking process. They're going to submit this as a rule. Can you describe what that process will look like, and what do you kind of expect that to look like?
So the rulemaking process begins with the issuance of a scope statement, and the scope statement says we're going to make a rule about X, and the governor has to approve the scope statement, and I assume that will happen today. Since they're going to proceed under the emergency rulemaking authority, the scope statement has to be published. There then has to be a period of 10 days. It's unclear whether they'll be able to publish it today or not. I should think that they would be able to figure out a way to do that if they wanted to. During that 10 days, the JCRER can have a public hearing. I don't know if that will happen. The law says that the agency cannot begin working on the rule until this 10-day period has passed. Once it has passed, then because we're dealing with emergency rulemaking, the rule can be promulgated essentially on that 10th day. And
does it require affirmative action from the legislature, or can they do nothing?
They can do nothing. Once the rule is promulgated, we now have a rule, the governor has to approve the final text of the rule. If it's an emergency rule, it can only be in effect for 150 days. It can be extended twice by 60 days by the legislature. And the legislature has the ability to block certainly all of the rule, and we believe part of the rule, given the fact that they've done that before in the past. And so, so a couple of things could happen. One would be that the governor would simply say, okay, you said that I need to do this as a rule. I'm going to do it as a rule, and I'm going to put it to you, legislature, and you can take it or leave it. That's one thing that could happen. The second thing that could happen is that the governor and the legislative leadership could get together and start to negotiate either about what form of rule would be acceptable to the Joint Committee on Rules and Regulation, or if this can't be done by rule because they want to do some things that they don't think that the court would uphold, what kind of legislation can we pass that would govern the next phase of our response to the virus? Now, I have to say that what we saw last night, we didn't really see a firm and unqualified commitment on behalf of either the governor or the legislative leadership to get together. I mean, the governor was, his attitude was kind of, well, this is on you now. The legislative leadership, I think it's hard to read what it is that they think should happen next, whether they think that we should just let things go, allow things to be worked out kind of by sort of a bottom-up view, with people deciding how they should act, and perhaps with some provision for what happens if the virus comes back in some type of more aggressive way, I believe is the term that Speaker Voss used. My own view has been, and the view of our organization is, they need to sit down and they need to talk about what the next phase of this is going to look like.
Well, that kind of goes to my next question. So, the legislature had asked for an injunction, or that the rule be enjoined, with the potential that they could have, had this period where they could have negotiated an outcome without removing the restrictions. The court did not do that. So a lot of people in Wisconsin woke up today and found themselves in a state in which the restrictions are lifted, save for a few counties. Is the cat out of the bag? Do you think they're going to go and come up with a joint plan? And after that, we'll get into kind of some of these county level restrictions.
Well, I think, in the aftermath of a court decision, there's a certain amount of emotional reaction. Either, you're happy that you won, or you're really hurt that you lost. And I think what remains to be seen is how both sides to this are going to feel, when they kind of say, okay, really what becomes workable at this point? Do we need to address liability concerns on behalf of businesses that open up? Do we need, if in fact we're moving, as I think it's inevitable that we were going to move eventually, to a situation where the emphasis is not so much on keeping everyone in the state of Wisconsin home, but asking persons who have special vulnerabilities to take extra precautions. Is there anything that you have to do to support the capacity of people to take those precautions? Are there certain types of gatherings that it would still be appropriate to place limitations on? Sweden is generally considered to be the model for a less restrictive approach, but Sweden does have some legal restrictions. I mean, there is a size limit on public gatherings in Sweden. Would that be something that would be appropriate for some period of time in the state of Wisconsin? And so I think as we move forward and, the governor thinks about that and the legislature thinks about that, it'll be interesting to see whether or not, they come together and figure out something that may look a little bit more like Sweden, or even may look a little bit more like the WMC plan, which I think had one of the advantages of that plan was that it provided consumers with a risk assessment based upon the location of a business and the nature of the business. And, perhaps they decide that makes some sense because right now it's difficult for people to assess the risk that they have based upon, the sort of level of uncertainty and confusion, which, still exists after 2 months in on this thing.
So schools are still closed. Is it your understanding that that there is any ban right now on the size of gatherings?
No, I don't think there is a ban on the size of gatherings.
Okay. But we should probably anticipate either at the county level.
I should say that I know that we're going to get into the operation of local orders in a little bit. There is no statewide ban.
Got it. So that does bring me to the local orders. So in the wake of this decision, Dane County, Milwaukee, and I think Brown, maybe Kenosha, a handful of counties have kind of extended or enacted their own safer at home orders. What types of authorities do counties have, and what might limit them?
Well, so there is a provision in the statute which allows counties to declare a local emergency, but also that confers what, at least at first glance, would be relatively broad authority on local health officials to take steps to control, the spread of infectious disease. The problem is that those provisions read a lot like the provisions that conferred authority on the Department of Health Services. And if the court concluded that the secretary had gone beyond what those general grants of authority to the Department of Health Services can support, then wouldn't the court also conclude that there is a limit on what can be done pursuant to this general grant of authority to local officials? And so it's difficult to say really how much authority the local officials have, other than it seems unlikely that this majority would support the proposition that a local official can simply adopt the provisions of Executive Order 28, as most of them have done. I think that it's reasonable to think that the authority of these local officials is going to have to be narrowly tailored to local conditions, that it may not be able for a local official may not be able to operate through kind of a stay-at-home order where people are basically ordered to stay indoors and not travel. that the order will have to be more directly targeted at situations in which there is more reason to believe that there are infected persons or the disease may spread. And I also believe that to the extent that these local orders are unlimited in time, like the city of Milwaukee order is, I think that they may be hard to uphold. So I think that there may be some, I also think that shutting down all businesses and then saying that, but only the essential ones can stay open. The court expressed a great deal, the majority expressed a great deal of skepticism about that as well. So I think that these local orders, they can be made because the local officials have some authority, but I think that authority is more limited and narrow than some of them are asserting in the immediate aftermath of this. And so it wouldn't surprise me if there were some challenges that are brought to some of these, particularly by litigants who are affected by some of the broader aspects of this.
Yeah, and it's interesting, and because I think you heard a criticism of some of these, or those who were opposed to some of these local orders of saying, well, a lot of folks wanted a regional approach to begin with. Isn't this something like a regional approach? What do you think of that?
Well, I mean, it is, and as I said before, I mean, I do think that it's reasonable to think, and one of the reasons that we have statutes that empower local officials is that, typically, really, we probably would expect the outbreak of infectious disease to be localized. And so I think it may very well be the case that a local order in the city of Milwaukee can be broader than a local order in the city of Wausau. But I still think that it would be difficult to justify and to have upheld all of the aspects of the current city of Milwaukee order, which is essentially a complete shutdown order with exceptions along the lines of Executive Order 28. So, but I do think, I would not say that there's absolutely no authority in local officials to do anything, because I don't think that's right. I don't think anything in the court's opinion implied that. It implied a narrowing of that authority, but not a complete elimination of it. Now, it would be different if we had the enactment of a statewide policy, because I do think an argument could be made, successfully made at that point, that the localities don't have the authority to contradict a statewide policy. It's complicated with counties because they have home rule powers, but I think at the end of the day, those home rule powers are pretty much paper tigers. And I think that if there were a statewide policy and a local policy contradicted it directly, that the local authorities would have to step down.
Feel free to send us along your questions. I've got a couple more here, but we want to get to any questions that you might have. I want to talk about the future a little bit and what this decision might imply for the future. So in the best case scenario, we are past the peak in COVID. Things are smooth sailing from now on. What we know is that there's a lot of public health experts who suggest that we will have some type of second wave or another outbreak, whether it's in the fall or the winter or next year. How does this decision impact the state's response to a second outbreak? What would you anticipate if we found ourselves in a position come September in which there was another outbreak? Could they do another stay-at-home order, another public emergency? I assume would be possible. Are there any limits that come out of this court decision?
Yeah, so one of the questions that has been raised is, well, could a governor who issued a public health emergency that was not extended by the legislature simply reissue the public health emergency on the next day? I think that would be extremely problematic, because to permit that would be inconsistent with the whole structure of the statute, which says you can act for 60 days, but then you can't act anymore if the legislature has not extended the public health emergency. So I don't think doing something like that would fly. But it becomes more difficult if there's a passage of time and that there's a material change in the situation on the ground. And so, if you have a situation where, right now, I mean, one of the ironic things about this is that going into yesterday's decision, right, the governor had 6 gating criteria to move into, phase 1 of his Badger bounce back plan. 5 of the 6 criteria were a green light. The 6th was a green light as well, in the sense that there was a downward slope in the trend of ER admissions for influenza-like symptoms, but the state was taking the position that the downward slope didn't meet academic tests for statistical significance when you correlate visits against time. And it was 0.21 and it needed to be 0.05. And so we were very, very close to those gating criteria being met. The governor had said, well, we need to be able to do 12,000 tests a day. While there has been some back and forth about whether this is really a right number and whether we really could do it, the state is claiming that they have the capacity to do 13,000 tests a day. So we were very, very close anyway. Now, what will happen if there is, a significant change in all of those criteria or assessments of the situation on the ground? I think it would be very, very hard to argue that the governor, because he once declared a public health emergency on COVID, can never declare a public health emergency on COVID again, no matter what happens. I think that would be a very, very tough argument for anybody to make. So, it could be the case that this will happen. But, the thing that we have to keep in mind, and I do think that there has been a subtle change in people's understanding of what stay-at-home orders were supposed to do. Initially, they were supposed to flatten the curve. They were supposed to slow the spread of the disease so that public health facilities wouldn't be overwhelmed. Somewhere along the line, people got the impression that what these things were going to do is basically make the virus go away and shouldn't be lifted until the virus had essentially gone away or wasn't much of a threat anymore. But none of the modeling that has been relied upon suggests that that would happen. And if you look at the modeling, the Hopkins modeling that the governor was relying on, with the safer at home order, if you kept the safer at home order in place for 1 month, 2 months, 3 months, in all cases, when you lifted it, there was going to be a spike in cases after that. Not the fall second wave, but a spike in cases simply because you lifted the order. Now, I don't know whether that's true because that model didn't perform very well in April. But I do think that we were coming to a situation, one way or another, where we were going to have to make the difficult decision as to how we were going to live with the coronavirus, because you can't simply, nobody believes you can simply stay on lockdown indefinitely or till a vaccine is found or till there's some type of magic treatment. And so in all events, we were going to get to the point where we're going to have to say, okay, because we cannot continue this sort of economic and social devastation that these orders necessarily entail, that we're now going to have to learn to live with this thing a little bit. And that's going to mean taking some risks that we weren't taking before. And I think that this did accelerate the arrival of that day, but that day was coming, and it was probably coming sooner than some people were recognizing.
And just to be clear, the Badger bounce back, that is no longer in effect as of yesterday?
Yeah, because the Badger bounce back had to do with lifting restrictions, when you could lift restrictions. But if the restrictions are gone, then it really has no meaning.
couple questions. Do you think that businesses will impose their own restrictions to limit their own liability for employees and customers? What do you expect from businesses in response
Yeah, I
to
mean,
that?
I think they will do that, and it's not simply going to be a matter of liability. I think it's also going to be a function of what the market demands.
A social expectation.
Yeah, and I think, sometimes we forget the fact that, the people that own business are people, and they don't want bad things to happen at their business. And so, the story I always tell is that, we were in Lee County, Florida in March, and there was no stay-at-home order in place. But when I left Lee County, but when I got back to Milwaukee, it didn't look any different in Milwaukee than it did in Lee County. Nobody was doing anything in Lee County. There were little check marks at the checkout stand at the pharmacy. There were businesses that could be open, but they weren't open. And so I think that you're going to see a lot of voluntary social distancing, simply because I think we kind of have this view that if the government doesn't mandate it, then it doesn't happen, but that's not true. And so I think you're going to see, you may see a lot less change than you might suppose. Although, apparently there were some bars filled last night, so there's that.
Yeah, and I think that's a really great point because comments from the governor in the last 24 hours have indicated he thinks we're in the Wild West, we're now in chaos. And yet there's a fair amount of evidence from places like Georgia, Florida, Texas, that when some of these restrictions are lifted, it's not like businesses just fill up, that all precautions are taken away. And it seems like people from our perspective generally believe that, human behavior and the market is going to drive how we move on from this thing.
Right, and I think there is an argument that can be made, sort of a wisdom of crowds argument that there may be some value in that there may be some value in allowing people to decide how much risk they can live with and what type of precautions work and what type of precautions don't work. And I think we're going to be seeing some of that go on. And again, I think it was inevitable that we were going to get to this point. You simply can't. I spend a lot of time reading about this stuff. Given the type of issues that are coming before our organization now, and I have not seen a credible argument advanced by any responsible person that explains how we could simply stay on lockdown for months and months and months, or into such point as, there's a vaccine, which of course there's no guarantee that there ever will be a vaccine.
This one's from Steve Coleman. He's asking about temperature checks and potentially other types of health measures that might be required to enter a business. Does any of that impact HIPAA or anything like that?
Well, I mean, it probably, and I'm sure it does. I think that on the one hand, if you look at the approach that the court seemed to be taking to this yesterday, things like that, things that are more directly targeted at identifying and controlling infectious disease, as opposed to assuming that everyone is infected and that all human contact must be minimized, are probably more likely to be found to be within the authority of the Department of Health Services when it comes to making a rule, or even local officials when they're ordering it should happen. Obviously, there are, privacy and perhaps other concerns that go along with that. But, I think one of the things that that business people are going to have to understand is that we live in a situation now where people have, even if you take a relatively sanguine view of coronavirus, people are frightened and they need assurances. And my guess is that businesses who provide those assurances and conduct themselves in a way where people can go into that business and think, I'm not taking an unacceptable risk by going in here. I think that there's going to be, forget about liability, forget about, just the right thing to do. I think there's going to be market value in that.
Right. Do you agree with that in terms of like mask requirements?
Yeah, I mean, I'm not one of these people that think that it's a violation of liberty to wear a mask. I mean, I don't know that we need to have a mask requirements, but the thing about wearing a mask is that a mask is more a protection of other people than it is a protection of you.
Yeah.
And I don't agree with this notion that not wearing a mask is a mark of your commitment to liberty.
Sure.
That's not a hill that I would want to die on. Whether or not they can be mandated, they weren't mandated, and I don't see that happening now. But I think you're going to see a lot of people just doing it because they think they should.
Right. So the court decision. Here's another question. Pretty clearly did not. It wasn't going to reopen schools. It gave the the health secretary still the ability to keep the schools closed, which is interesting given that what you indicated about the gating criteria. If they had hit all 6, the first phase of the Badger bounce back would have allowed them to open schools. What's your expectation on whether schools are? It sounds like they're going to stay closed through the end of this year.
Yeah, I mean, it sounds like that. I mean, it but still could be done.
Right.
I think that. I mean, it's hard to say. I mean, I can't really speak to why the schools were not opening. I don't. Again, part of the problem with the situation that we're in is that there is far more that is unknown than it is known. And so, would opening the schools really contribute to a spread of the virus? I keep seeing evidence that, maybe that assumption was wrong and it wouldn't. But I think you're going to have, I think you have opposition from teachers unions. I don't know how that's going to play itself out.
Question I had pertains to now everything's quote unquote open. Are there legal ramifications? What happens if a person is immunocompromised or is just simply afraid to go back to work? Can they be fired? Is there any recourse for that person? How does that work? Do you know?
I mean, I don't think there is any recourse for that person now, unless you could somehow redefine that as a disability. And I haven't worked that through, but it seems to me that that's unlikely. And in any event, it's tough to see that in all cases there would be a reasonable accommodation that would be available. I mean, there are lots of people that can work at home, right. And my guess is that's going to continue for a while. But there are other people who can't. And so even the disability claim, I think, would be problematic. It might make them eligible for government benefits. But I do think that that was at least one area for possible consideration by the legislature, because, people will differ in their ability to, protect themselves. There are some people who can do it easily, right? And they're not losing income. They can stay home all the time if they want. There are other people for whom that becomes more difficult. And then the question becomes, should the legislature do something either as a matter of, support for those individuals or to ensure that they don't go out because, there may be some value in that as well. But that's the type of thing that is hard to just have accommodation bubble up. I mean, it can in some degrees, but there may be circumstances in where it really can't.
Yeah, I just think about the question with the schools, right? So, school opens up next fall and there's a 65-year-old teacher who is immunocompromised. What, are they What do they do? Are they required to go into work, and how does that all work? I think there's going to be a lot of questions like that.
Again, unless you can make an argument that that they're disabled by their susceptibility to the coronavirus, I think they may be without a legal remedy.
Question from Megan: are the EFMLA benefits still available to employees, or does that lift now with the order?
Well, I mean, I think I would have to look at that. That's a federal provision, so federal law wouldn't be changed, but it would really depend upon what triggers the availability of those, and that's not something that we've looked at.
Sure. So I want to wrap this up and just thank everyone for coming. Rick, I just want to end with one kind of open-ended question for you. You know, a lot of stuff's happened in the last couple of months that I think back in January, even February, would have been unimaginable in terms of restrictions. How are you thinking about those tensions between liberty and safety and security moving forward here? Do you expect the legislature to take a look at some of these emergency powers? And how do you hope we as citizens kind of emerge from this lockdown thinking about our own liberties?
Yeah, so, you know, Jonah Goldberg calls this the confirm your priors virus. And that, you know, people's position has tended to sort of correlate with, you know, what they believed going into it. I mean, this has been difficult for people like us who are sort of more, you know, Reaganite, classically liberal conservatives who are very freedom-oriented, very market-oriented, and who place a great deal of value on our constitutional freedoms. And so for someone like me, when I sit down and I read, you know, the Safer at Home order, my blood wants to boil, because when you start with the proposition that a government official has ordered people to stay in their house, I mean, I'm sorry, I get triggered by that.
Sure.
And but at the same time, there's a long tradition in the law of the government being able to do things to control infectious disease and pandemics. And so we're left with this conflict now. And for a variety of reasons, organizations like ours have been very, very careful in hopping into the litigation fray, both because we didn't want to make bad law, and also because, you know, we recognize that, particularly at a time of fear and uncertainty, dogmatism probably isn't the order of the day. And as this thing sorts itself out, we can then kind of figure out where the limits are and when the guardrails need to be enforced. And so we've always said that, you know, if we're going to accept this, our acceptance should be contingent, it should be questioning, it should be limited in time. And I think that yesterday's decision was an example of that, where you know, basically the court is saying, look, you had 60 days to proceed in a way that we normally would not want law to be made, but the 60 days is over, and now you got to do it the right way. And I think that that's important, because although we certainly can acknowledge the fact that even under our constitutional doctrine as it exists, that there can be some infringements on liberty that we would tolerate in this circumstance that we would never normally tolerate. We can't, as a result of that, say that the Constitution goes out the window and that the rule of law goes out the window because we're afraid. And so I think that this is an important reminder that things have to be done the right way. And you know, the fear that you always have when you compromise and you say just this once in response to an external threat, then you know, the Overton window shifts and we begin to tolerate restrictions on freedom that we normally wouldn't tolerate on an ongoing basis, and that's not something we should do.
Well, thank you so much for everyone who's joined us here today. Thank you very much, Rick. And we look forward to having you join us for another discussion in the future with Rick Esenberg. I'm sure there will be more conversations to be had as this thing develops.
Thank you.